Without further ado, I'm going to introduce our first speaker and host for the evening, Judge Bianco, and then I'll turn the program over to him. So Judge Bianco graduated from Georgetown University and Columbia Law School. Prior to his appointment to the bench, Judge Bianco spent most of his career as a federal prosecutor, first in the Southern District of New York in Manhattan, where he became deputy chief and then chief of the Organized Crime and Terrorism Unit. In that capacity, he worked on many terrorism investigations and prosecutions, including the September 11th attacks. He then worked as a deputy assistant attorney general in the Justice Department in Washington, D.C., supervising, among other things, the counterterrorism unit. In 2006, Judge Bianco was appointed to be a district court judge in the Eastern District of New York and was based in Central Islip on Long Island. And in 2019, he was elevated to the United States Court of Appeals for the Second Circuit, where he continues to serve. Judge Bianco also currently teaches several courses at St. John's Law School, including one on sentencing. So Judge Bianco will introduce the rest of our speakers, but I'm going to turn it over to him. Thank you, everyone, for coming, and enjoy the session tonight.
Thanks, Alana. Good afternoon, everyone. It's great to be with you, and thank you for joining us. As you know, our topic today is sentencing, and our goal is really to take you on a 90-minute journey through federal sentencing law and procedure and policy from 5 different perspectives. And we've put together an all-star panel and who will give you those various perspectives one by one. We're not going to all be speaking at the same time. We're going to spend about 10 or 15 minutes with each person. And I want to thank all of our panelists for graciously agreeing to be with us today. As Alana mentioned, if you have any questions, I have the chat box up. And although I'm moderating, I'm happy to pose your questions to any of the speakers, and obviously you can ask me questions as well. Our goal is also to, we're recording this, our goal is to make this available, not just to those who are with us today, but to other teachers, so that if you have other teachers who you think might benefit from this program, we will place it on our website when it's done. And we also are hopeful that you might be able to show it to your students as well. So I'll get started from the perspective of a judge, although our last speaker, Judge Gleason, I think can also speak to that perspective among others. But I often get this question from a lot of different people: what's the hardest thing that you do as a judge? And judges do a lot of hard things and complicated things, but my answer to that question, I think, is probably similar to most judges. And that would be sentencing by far. It's not even, there's nothing even a close second in terms of the difficulty when it comes to sentencing. And, you know, it doesn't get really any easier. I presided over hundreds of sentencings. I teach sentencing. I review sentencings now in the appellate court. And notwithstanding that, sentencings that I do now are just as hard as the ones that I did at the very beginning. And I was thinking about why that is. Why is it so difficult? And I think this is a good place to start. One reason is what's at stake. You have a person's freedom in your hands, and you feel that weight and that responsibility. And when you're sentencing someone, I'm in my courtroom right now where I do sentencings. When you look out at the defendant, you see not just him, behind him, you'll see often dozens of people, his family, his friends, his neighbors. And as a judge, you are keenly aware. In fact, it's very difficult sometimes for you to even look up because it's just a hard thing. It's a very difficult thing. You realize you're sentencing those people too. You're not just sentencing the defendant, you're sentencing everybody who loves him, who needs him, who depends on him. I think that's one of the things that makes it a difficult process for all judges. You understand the importance to the community, you understand the importance to the victims, and it can be very intense. It's really, I sometimes describe it as the height of human drama. The only thing that has that same level of intensity is when a jury comes in the room with the verdict that has that similar intensity to it. But often the courtroom is literally divided in half. You have the defendant and his family and friends on one side of the courtroom, all hoping for the most lenient sentence possible. And on the other side of the courtroom is the prosecutor, and behind the prosecutor might be victims' families, FBI agents who worked on the case, who are hoping in many instances for a much different result. So the stakes could not be higher at a sentencing. The second aspect to it is sentencing is not a science. And there are many parts of the law where I feel if you give me enough time with the help of my law clerks, we'll figure out the right answer under the law. We'll do a lot of research and we'll figure it out. Sentencing does not really lend itself to that. It's a highly discretionary process, and we'll discuss that a little bit as we go forward today. And you're trying to measure various factors that involve human nature. So for someone like me, who's a perfectionist, let's go up with a perfect number, it can be a very challenging process. You're trying to measure remorse. Is the defendant, when he says he's sorry, does he really mean he's sorry, or is he just saying he's sorry because he wants leniency? You're trying to measure future dangerousness. Does this person pose a danger to society if we let them out now? If you think they're dangerous, you have to try to predict when will they not be a danger? How long do they need to be in jail before I believe the community will no longer be a danger? How much time is enough to reflect the seriousness, the harm that they did to the victims? All of these things you have to try to measure them and then balance them. And that's a very difficult process for me, and I think for most judges. And then the final aspect as it relates to the difficulty of that whole process is you learn this over time. Nobody has all good or all evil on the ledger. It's just not the way human nature is. Someone can do something very bad and cause a lot of harm, but in other aspects of their life, they're doing great things. I often tell people, I could hand you 50 letters about someone and you'd read them and have all be filled with wonderful things about what in their family, in the community. And you would read these letters and say, I want to meet this person, this wonderful person. And I would say to you, well, that person, is in jail serving 10 years for robbery, armed robbery. And I think people would be shocked. They would be shocked. How can that be? But as a judge, you see that constantly. And so, again, you're trying to weigh all those things. You're trying to look at the person's whole life and not just sentence them based upon, what might be the worst judgment they ever made. You have to look at their motivations and all the circumstances surrounding it. So that's why I find it so difficult. You struggle with it. Sometimes on the car ride home, I'm thinking about whether the sentence was too high or too low, but you do your best to make sure you're considering all the information, you read every letter, you're considering it as seriously and genuinely as you possibly can, and you do the best that you can under all the information that you have. In terms of why this is more important, I guess more globally or as a nation, and many of you probably know this, the United States has the highest incarceration rate in the world. I think I looked up the numbers earlier today. I think it's over 2 million people in jail in the United States, with 1,800 state prisons, over 100 federal prisons, thousands of local prisons. So I think the responsibility falls on everyone: judges, lawyers, legislatures, and the community, to look at that, look at our sentencing policy, look at our sentencing procedure, to make sure that our criminal justice system and sentencing in particular, that it's fair, that it's just, and that it's equally applied, and to make changes where there needs to be reform. We should consider what we're doing, whether it makes sense, and whether we can do it better. And that's a really important part of the law, and it's certainly an important part of sentencing. And you're going to hear about that today, I think, from more than one speaker. Before I go to our first speaker, I just want to give you, and many of you may know some of this, some of you may be lawyers yourselves, but I just want to give like 3 minutes on the law of sentencing. I do this in a whole semester at St. John's, but I think I can do it in 3 minutes for our purposes today. For purposes of sentencing procedure, and I'm talking about the federal level, although there are many similarities in terms of procedure, but whether you're convicted by guilty plea or by trial, once you're found guilty, a judge will set a sentencing date, usually about 4 months out, and then a pre-sentence report will be prepared by the probation department. You'll hear from Robert Capers, the head of probation, who will explain that process to you. That's trying to give as much information about this person that the judge could possibly have before he or she sentences them. In addition to that report, both sides can put in written submissions of whatever they want. letters, medical records, whatever they think would be something they would want the judge to know about from the prosecutor's standpoint, the victims or the crime, they would submit, and the defendant would obviously submit whatever mitigating information he or she had. At the sentencing itself, and I think this is a very good example of procedural justice. I think it's sort of manifests itself in a very pronounced way at sentencing. Everybody gets a chance to speak at the sentencing. The law requires it, and the prosecutor will speak under the Victims' Rights Act. The victims have a right to speak. Defense counsel has the right to speak, and the defendant also has a right to address the court. Even if the defendant writes a letter to the court in advance, which he or she might sometimes do, they also have the right to speak orally at the sentencing itself. And once everybody has spoken, the judge pronounces the sentence. The judge is required to give some reasons, both orally and in writing, for that sentence so that it can be evaluated both by the public and by the appellate court if there is an appeal. So that's the procedural part of it. In terms of the substantive law of sentencing, and this is I don't know how much we'll get into this today, but there's a big variation between New York State and federal law in terms of the substance of sentencing. Under state law and the practice of sentencing, the judges are highly involved in the plea negotiations, and everyone sort of knows going to the sentencing what the result is going to be. The judge has sort of signed off on it. And so there's not a lot of, drama in that respect, usually at state sentences. Federal sentencing are the exact opposite. The judge is involved in plea negotiations. It's not allowed to be involved in plea negotiations. And so at the time of sentencing, there are many sentencings that I have where, especially with cooperating defendants, where he could walk out of this courtroom with instant freedom, where I could say time served, or I could give him 10 or 15 years or anything in between, and all of it would be okay on appeal. Is within my discretion. So that's how broad the discretion is of a federal judge at sentencing. But the law does require the court to consider a whole series of factors in a statute called Section 3553A. And I'm not going to go through all the factors with you, but you can probably predict what they would be. They're very broad. The nature and the circumstances of the offense, the history and characteristics of the defendant, good or bad, the need to protect the community, the need to afford adequate deterrence to criminal conduct, the need to make sure that there's not sentencing disparity among other similarly situated defendants who've done the same crime. So the law requires a judge to consider those factors, but both the Supreme Court and the appellate courts have emphasized what weight to give those factors, how to prioritize those factors in any particular case is completely up to the judge. So you retain that discretion, even though you do have a framework that you're supposed to analyze it in. And then the last thing I'll mention is there's something called the sentencing guidelines that were created in the 1980s. It's a big book. There's a sentencing commission that essentially creates, they're almost like mathematical formulas for certain crimes and tries to measure them with a score. So if it was a robbery, you would go to a certain guideline and it would have a certain number, and then it would start asking you questions. Was a weapon used? Was anyone injured? How much money was taken? Was anyone tied up? And based upon those, the score can go up. It could also go down under certain circumstances. And then it takes your criminal history and gives a score for that. You put those together, and then it gives a range within which you could be sentenced. They used to be mandatory, those guidelines. The Supreme Court over a decade ago in a case called Booker said they can't be mandatory, they can only be advisory. And so now we get that number, and it might be, it could say 10 to 14 years, it's in months, but 10 to 14. Some of the ranges are very broad. 30 to life can be a range. And those are helpful. They're starting points for a judge, but it's ultimately up to the judge as to how to weigh those as well. There's a question about how did they come up with these sentencing score guidelines? It's over time. There's a sentencing commission, and they change over time. But there's an entire process for trying to do that. But I think everybody understands you can't reduce people to mathematical formulas like that. But I find them helpful, and at least giving me some idea as a starting point of where the sentence might ultimately end up. I know that was quick, but I'll leave it at that, and maybe we'll cover some of those aspects of procedure and law as we go through each speaker.